So good afternoon, everyone, and thanks very much for coming. So today we're going to explore the legal nature of carbon credits. I assume firstly that everyone here came on your own volition, because this can be a bit nerdy and can be technical, so you'll have to buckle up for what I hope will be a riveting conversation. So again, firstly, what are carbon credits? What is their legal nature? For a market that is at least 25 years old, it does seem strange to be discussing this issue. It has, however, attracted the attention of multiple trade bodies, market participants, and standard setters such as ISDA, UNCITRAL, UNIDROIT, IOSCO. And we want to have a discussion today with this distinguished panel. Now, just to frame the overarching topic, so we work off the same understanding. And it's very important, actually, when you have lawyers, you set the rules on a panel. Otherwise, people go really off boundaries. Firstly, the legal nature of carbon credits refers to the fundamental legal characteristics of these instruments in a relevant jurisdiction, whether they are considered property rights that can be bought, sold, traded on markets, and how are they treated by law for banking, capital, and insolvency purposes, as well as for tax purposes. And today we're only discussing VCCs, not compliance credits, which have their own statutory basis. And lastly, we are not discussing the environmental concept underlying or underpinning these credits. So no discussions on additionality and so on. So that might be a disappointment to some of the methodology junkies like Ansari here, but so we'll not speak on that today. So we're going to start off with our first question to Ting, and I'll do that only because she invited me to moderate this panel, so it's only right that she does. And coincidentally, because she's also authored a paper on this very topic. So Ting, first question, what motivated GenZero to issue the legal paper, and why do you see the legal treatment of carbon credits as important?
Thank you, Jason. And I'm looking forward to the discussion, today on this nerdy topic. A really big shout out, first of all, to our co-authors, Adrian and Yong-Sing and his team at Allen & Gledhill, leading law firm in Singapore, who co-authored this paper with us. And we benefited from the reviewers, Danelle from Center for International Law at National University of Singapore, and Joyce from DBS. So thank you again. We'll share the link to the paper later. I welcome feedback and input, and you can share your input through the QR code that is on your card as well. But otherwise, happy to have a chat later, and really looking forward to hear feedback from my fellow panelists. Just coming back to the question, we heard from Dylan that the carbon market, the voluntary carbon market, and VCCs, voluntary carbon credits for short, are important in our toolkit to scale up and to achieve our climate ambitions. Now, I won't go through that again, but we know that the growth of a relatively nascent carbon market is important to have certainty and clarity. Now, because of that, we wrote the paper, and we see it important in 3 key areas. You'll see it up on the screen. It's kind of a summary of the paper. First, we see that it's important for the buying and selling of voluntary carbon credits. Now, it gives certainty that the buyer has the ownership and the title to the voluntary carbon credit that it buys, right? And in the paper, you will read that we believe that it can be intangible property. And what does that mean? Intangible property, let's say, some of us are familiar with shares, software, trademark, patents. So these are intangible properties, and we believe that under the existing laws, principles, case law, in Singapore, it can be intangible property, and it's likely to be applicable in quite a number of common law jurisdictions. Now, what does that mean, right? It will give buyers an exclusive right to the carbon credits, and it's even more important when there are intermediaries in the sale transaction. So I think for lawyers, we are familiar with this concept called a right against the world at large, and this speaks to that concept. Now, the second key area is VCCs as collateral. Now, we know that financial institutions are able to structure security when they give loans, when they're clear on the kind of security that they can get, they then can give the loan. So for example, when you buy a house and you want to get a loan, the bank will find a mortgage, and they can do that because they are clear that the mortgage is enforceable. It is actually a clear thing that they can register at the land registry, and they have a right to enforce on it. Now, for voluntary carbon credits, when the banks or the financial institutions look at it as a collateral, they will have to think about, is it a charge or an assignment? And it depends on what's the legal nature. And each of them have their own formalities to be able to perfect and have an enforceable outcome later on. And hence, being clear on that is going to help the financial institutions to give more loans and enable sustainable financing. And thirdly, lastly, trust and insolvency. It gives certainty of claim at when there's insolvency, right? And we're just discussing during tea just now. There doesn't seem to be many disputes based on insolvency at this point yet for carbon markets, but we don't have to wait for a dispute to come up. I think the market requires certainty in that, you know, if as a buyer, if I have paid and have not taken delivery, and the carbon trader goes bust, you must be able to have an enforceable right on the VCCs. And as an investor, if I have asked, if there are funding structures that require me to have a trust to be held, or rather a trust on the VCCs for the benefit of the community, or for the VCCs to be held on trust for the funders, this is a key concept that will enable more funding. So as a result, we thought it's important for us to kind of write about these and think about what are the possible ways of thinking of the legal nature of carbon credits. Yeah.
Thanks. So there's a lot to unpack there, but I'm not going to give any respite to the audience. We're actually going to pile it on, and we're going to bring Richard into this conversation. Welcome, Singapore, Richard.
Thanks
Good to
so
see
much.
you. Now, Linklaters discussed this issue in a paper with ISDA in December 2021, and you have been involved in the UK Law Commission on Digital Assets, where you actually touch on the nature of carbon credits in various parts, right? Now, could you share with us your view? And actually, because you promised to do this for free, I'm going to ask Linklaters 2 questions, and I'm not going to get charged Linklaters rates. Do you also believe there's a difference between the civil law and the common law? So, Richard.
Thanks, Jason. Just so long as you don't get me to sign a legal opinion on stage, it's all fine. I think my key message really here today is to try to dispel a myth, which is that you need in common law jurisdictions to wait for a case specifically deciding a point in order to achieve the requisite degree of legal certainty in all of the areas that Ting has alluded to. And really, all of those areas are the absolute most fundamental commercial actions that actors might look to take in these markets. Can you buy or sell one of these things? Can you take security? Can you create a trust? What are your exposures on insolvency, etc.? And in a sense, the whole point of common law is to be able to extrapolate from existing case law principles and apply them out of context and say, so long as I have a thing that broadly has these characteristics, even if there isn't a case specifically deciding that point, I know what the legal treatment is going to be, because that is the whole case law system. And so as Jason mentioned, that is the very question that has caused the Law Commission in the UK to write a 500-plus page report in the context of digital assets. And in some senses, you might wonder why I'm coming at this from a fintech perspective, but really what's going on here is the emergence of new forms of intangible assets. And so there's a commonality here with, yes, digital assets, but also things like milk quotas, rights to the registration of personalized number plates, waste management licenses, all of these assets that tend to be registered registered assets, and so their existence really is represented and constituted by an entry in a register. What is the nature of those assets, absent a specific case, or in a civil law jurisdiction, absent a specific bit of legislation that clearly addresses those questions in civil law? So the answer under English law is there's a sort of well-known case, without sort of going through all of the detail, but the sort of Ainsworth tests as they're known. And essentially, do you have a thing that is definable, that is transferable, and that has a degree of permanence or stability? Now, in the case of carbon credits, the first two are pretty straightforward in the sense that, yes, you have a thing that's clearly definable and identified in the market. The whole point is that it's transferable by entry in a register. So a lot of the debate has actually focused on how stable and how permanent carbon credits are. And in particular, within the context of a contractual framework and also a central role of the registrar, can we really say that carbon credits have a sufficiently kind of independent existence from the registry and from the role of the registrar in order to be able to conclude that they exhibit the hallmarks of property as Ting's alluded to? To cut to the chase, I think the short answer is the Law Commission report, the final report, comes to the conclusion that essentially, provided that certain characteristics are met, yes, English law, and one would hope that the position would be common across different common law jurisdictions, that actually carbon credits quite clearly represent and have all of the hallmarks of property. And in particular, it's quite easy to think of the role of the registrar as being central to the carbon credit, but it doesn't exist in a vacuum. It exists within the context of a carefully constructed contractual framework, and also in many cases fallback mechanisms to ensure that actually, if there are issues with a particular instance of the registry, actually there are business continuity fallback procedures and other fallback mechanisms that grant the carbon credits a particular degree of permanence and stability, so that hallmark characteristic is met. So, long story short, in most common law jurisdictions, one would hope that some variant of that logic would apply, and actually, even absent a case specifically deciding the point, there's a sufficient degree of existing legal certainty in order to found a stable legal foundation to the market. Now, just to speak a little bit about on the civil law side, it's almost the inverse problem that is faced in many cases with regard to the common law jurisdictions, because in a number of cases, particularly so in the digital asset space, but in other instances of new and emergent assets, civil law jurisdictions have actually been quicker than the court process, the process of disputes coming through the courts, and enacted specific legislation to address a number of key, create legal frameworks around some of these assets. That has not yet happened in a number of civil law jurisdictions in relation to carbon credits, but what is recognized is similar to the points that I've just highlighted, is a general concept of property. And in many cases, one can look to that general concept of property to say, yes, okay, there isn't a specific law addressing the case of VCCs, but VCCs do exhibit all of the hallmarks of property, and in particular, all of the hallmarks of an intangible form of property. So I would invite the audience to challenge the sort of naysayers out there, people that question whether VCCs are capable of amounting to property. And in light of some of the principles that I've just outlined, actually, when push comes to shove and you really challenge people to ask, why, do we really think that there is as much uncertainty as is sometimes expressed in the market? I think some of the principles that I've just outlined are actually very strong points to be able to come to the conclusion that a sufficient degree of legal certainty actually already exists in the market. Now, we can then talk a little bit about which jurisdictions and jurisdictional variances and how you can structure different arrangements to situate your project in a particular jurisdiction to achieve more legal certainty, but I think that's probably a topic for another day.
All right, thanks very much on that point. Actually, I want to pick up on your one of the last things you said there on the practical element and bring Robin into this discussion. So Verra, 1.2 billion credits issued, 704 million retired, and I know this because I checked the website yesterday. There's a lot of stuff that goes on in dealing with these credits. But how do you guys in Verra look in terms of the registry, the custody, and dealing with all these volumes of credit? Certainly this issue has to be something which you adapt or get comfortable with in structuring the whole framework.
Yes, thank you very much, Jason, for the question. Thank you to my two fellow panelists who I think set this up very nicely and in many ways said a lot of what I was hoping and would be said, because it's good that we've actually constructed our system very much aligned with what has been described here. It's always nice when practice and theory align. And thank you to all of you. It's nice to be among friends, as Dilhan said, and I'm sure an even greater number of opinions out there. What I want to take a step back, just if I may, for a moment, and just say that the role of the voluntary carbon market is one that exists because governments haven't moved far enough and fast enough. And that's not just, of course, on the emission space, I'm talking targets and policies and measures, but also the legal vacuum which has existed. And Verra, and not just Verra, there are many other crediting programs. I think I saw the chair of Gold Standards Board here as well, so not just us, but many others have sort of rushed to fill in that vacuum. And the way in which we've done that is precisely, well, both through the outreach that we have to projects, registering projects, issuing credits, and so forth, but also how we've approached the definition of credits. And we've very much reflected a deliberate choice to structure our program rules, the design of our registry, which is perhaps more aptly described as a register, and essentially the entire apparatus is all around trying to favor a definition, as has been outlined here, of credits as property rights. And so that takes various forms. It takes the forms of our serialized numbers on the registry. It takes the forms of the definitions that we've set out in the program rules. How we address issues of permanence in terms of the permanence of the credits and what happens if there are issues with the underlying projects. How Verra itself describes the registry and the register. It is a register of claims to the credits. We record faithfully the transactions as they are recorded to us, and we track on that basis. We, however, do not hold the credits. They are not items that are held by Verra. That provides an element of, I guess, insolvency remoteness in case Verra itself were to go insolvent. And it also, and then that's how we sort of constructed the entire system. In terms of why we've done that, I think that the previous speakers have outlined why that is. It brings the benefit of a property rights regime around the world to bear. And I think the other critical point, which I think has been alluded to, but maybe I'll say it explicitly, we do and we want to sort of see the growth and maturation of sophisticated secondary markets in this area. The primary market can take us only so far. We are aware that there are many entities out there with the resources and the finances and the capabilities out there, but they have perhaps different risk profiles, and it is through the secondary market with which they are going to participate and move the sums of money that are truly necessary. And we do feel that a more rigorous approach to how property rights are defined and how we can reflect that is our best contribution to making those markets work. In terms of issues I think you touched upon, ones of security, collateral, and so forth, I touched upon the insolvency point. With respect to issues of security, I'm aware that there are people out there who are looking to Verra to consider being a registry of security interests as well. So far, we've kind of resisted that, largely because it's our position that we're not actually the ones holding the VCUs, but we are. What I can say is that's something we are looking at. We are considering whether or not this is something that we should be doing. There seems to be certainly a market need for it, and we are looking at it, but right now that's not something that we do.
Jason, can I
Yes, please.
just step into your shoes a little bit? So has there been any insolvency of buyers or owners of VCCs on the registry, and any issues arising out of it?
I wouldn't say there have been actually issues so far. I mean, certainly, entities come and go, and I believe the issue of an insolvency of an account holder may trigger some sort of notification requirements or action on the part of the Verra registry. And then in such cases, it would be a question of with which entity are we then dealing with, which may come in to take over the rights of the...
And no disputes so far. Okay.
Ting, actually, maybe I think you asked that question as an investor, but I'm going to pick up on that theme. Simply, how does GenZero deal with this issue as you invest and participate in different jurisdictions? Some of them who might not have, I'm trying to think of a word, maybe advanced way of looking at these very complex issues. But what do you look out for? How do you protect yourselves when you deal with these issues in these jurisdictions?
It is a real problem, right? And there is no silver bullet. And I think that what we've tried to do is to put as much so-called description into how it's a bit like the Verra, or like the UK model, where you don't call it property because maybe you are not the lawmaker, but you try to give it characteristics of a property. You take security and you call it, you have certain rights over it as if you have title. But truth be told, I think harmonization is going to be helpful for investors like us, and hence we write this paper, right? Because when you have different jurisdictions, when you have project developer, registry, security agent in different jurisdictions, you truly run the risk. And harmonization will reduce that risk for us, and also lower the friction cost, the cost that people are imputing to these structures because of the uncertainty. I think in the paper we wrote about how we think there is a strong tendency for market participants to converge around jurisdictions that have a bit more clarity, especially legal clarity. And our view is that if certain regulators can come out and state a position, articulate some guidelines, it will really help the market. And it will also help other markets to come and also take a certain position. And I know there's a lot of discourse in the international organization like ISCO, ISDAR, and UNIDROIT on this topic, but I almost feel like it's going to be quite difficult in the short term for certain jurisdictions to say, I will take this position that UNIDROIT tells me to take, right? Because we have different jurisdictions. But if the market, if certain leading countries can take a certain view, I think it will help.
Yeah. So this is where I break the third wall and volunteer my opinion. Again, maybe it's because of my background, but I think on derivatives, everything has a price. When you converge on a jurisdiction which has some legal certainty, how they treat investors, how they treat the projects, and this also goes beyond that to things like revocation and all those debates that are happening, that will filter down to a price and to a jurisdiction in which there will be a bit more granular, and the more attractive jurisdictions will be able to charge premium for that, right? So again, that maybe is the short term while people try and resolve these issues. Back to Richard, actually. I'm going to go back again to talk about the novel assets. What sort of disputes have you seen in the novel asset space, right? Which might follow the same trajectory, the disputes actually, and appear in the VCC world simply because of this issue of legal uncertainty. We can guess that it will be insolvency, ownership, and so on. But can you just maybe share some of the actual real cases where this has happened, and we can extrapolate on how that could happen in the VCC world?
Yeah, sure. So it's in many cases as to be expected, but the most proximate example, which has actually worked its way through the English courts, is in the compliance markets, where there has been some case law relating to frauds in relation to some corruption of registers and transfers on to innocent third parties, and ultimately the courts having to make some very difficult determinations as to where the loss should lie between an original holder and and a transferee in good faith. Now that taps into an area of law which in its own right, in many jurisdictions, is extremely complicated and in some cases uncertain. And so I do want to draw out this idea that whether or not a VCC falls into the category of constituting property rights in its own right, it's only the beginning of the discussion, in the sense that you then move on to questions as to how transfers are affected, what are the consequences of that, what rules of transfers apply, and that all of that matters in terms of how much diligence you have to do when you are the transferee of a credit, in terms of the chain of transfers. Do you only care about your immediate transferee? Do you have to look through the chain of title and investigate the full chain of title? All of those questions that financial market infrastructure has solved over the evolutions of many, many years of different layers of legislation. I think all of those areas are relatively greenfield areas for the development of law, and there will be a lot of case law and complexity arising in relation to that. I think the other key area that people are really focused on, as has been mentioned a number of times, is insolvency. I think one point that is really important, though, to highlight on the insolvency side of things is that it's not the characterization of VCCs as credits as property in their own right it's not a zero-sum game, in the sense that if it's not the case that they amount to, so if they do not amount to property in their own right, they may nevertheless amount to a bundle of contractual rights. And setting aside a lot of academic debate, you can own contractual rights. And so the question of insolvency, provided that you've set up the arrangements properly, if there is an intermediary involved, that intermediary may well be holding those contractual rights on trust, etc. So it's not the end of the story again. If in a particular jurisdiction carbon credits are deemed not to be property, it's just you have to make sure that arrangements are set up so that you're not exposed to unwanted credit risk. And so I think that's just another point to bear in mind. Obviously, the most likely case law in that context is where actually arrangements have not been set up with that in mind, and intermediary arrangements in particular have been poorly drafted or poorly thought through.
Just to add again to the complexity, there's a lot of talk or discussion on blockchain or DLT as being a sleeve, right, to provide some certainty. And now I thought for many years that was just making a complex issue even more complex, and layering DLT or blockchain on top of it wasn't so good. But you have a view that it might not be all complex, it might actually be good. Could you explain?
Yeah, it's interesting, and this is really an area of kind of interaction between the digital asset side of things and the carbon credit side of things. There's been a lot of progress made on the digital asset side, including a number of cases that have made their way through the courts. I myself sit on the UK Jurisdiction Task Force, which had commissioned a legal statement on exactly this question in relation to digital assets. And setting aside the fact that a lot of the case law is preliminary or first instance or early stage case law, there is a mounting body of case law now to the effect that certain digital asset structures can amount to property, be recognized as property. So in a paradoxical way, although digital assets are an entirely novel asset class, there are attempts out there to marry up the relative legal certainty of having essentially a register on a blockchain, where that is structured in such a way that it can fit into that line of case law, and to say, actually, if what you end up with is some form of VCC that is a certificate that exists on a blockchain and that exhibits the hallmarks that are now making their way through the courts and being identified as proprietary, actually perhaps some of the perceived uncertainties that we've been discussing can be put to bed by linking that your certification that exists under a VCC to entries in a blockchain. Now again, that's very high level, there's a lot of complexity there, but it's just interesting to see how some projects are looking at those two worlds and thinking, can we marry things up and achieve a higher degree of legal certainty in this area?
So you mentioned register, and since we have Robin, I was about to ask you, how do you see a world in which the blockchain and the registry and legal nature all working together to give some certainty. Is that something which, from your perspective as a standard setter, as a register, would like to see?
Yeah, I mean, that's a large question. And it's a question that, I can't actually say too much about right now. What I can say is that it is an area of study. I think that there are absolutely voices which would say that this is the right direction to go in for, I think, the reasons that have been set out. And I think that there are other voices which query whether or not it introduces unnecessary complexity and what the benefits of this would be, and are they too speculative, and is this what a priority for the organization and the market is right now. I can say as well that it is an issue of study, but that no firm way forward has yet been chosen.
Right. I guess the lawyer shorthand for that is still in square brackets. Yes. Okay, I think we have 10 minutes, so we'll take some of the questions. Okay. Maybe this, the first one here. What are some challenges you faced or anticipate with the regulators on classifying the legal nature of carbon credits? Right, it's up there. Ting, do you want to take that, since again you wrote the paper? Co-authored the paper.
Well, co-authored, yes. Well, I think the regulators, actually the whole of last 2 days, right, we're talking about how we would welcome regulatory oversight for the voluntary carbon credit market. And I think the regulators are looking at this space, this issue, and we've had some conversations, but I feel like most regulators are open, particularly those in Singapore, to have a conversation, but it's not entirely clear always how they would lean, because I think for regulators, there's a whole toolbox of in the arsenal, right? They can either come up with mandatory guidance or non-mandatory guidance, regulations, all the way to legislation. And it really needs a consideration of speed, because of obviously legislation and regulations are a little bit longer to come up with. That's why I feel like guidance and codes are helpful. The other thing is that I feel for regulatory oversight, sometimes the market thinks that it's good, but it doesn't really know what it's actually asking for. So you could have more regulation and it could totally chill the market, or you could have regulation and have certainty, a bit more clarity and certainty. And it's really a calibration exercise. Maybe I'm not answering the question directly, but I think the regulators are taking time, and in some ways it's a little bit frustrating to kind of say, hey, you should take a position. Yeah.
Yeah. I'll just add, again, I don't want anyone to leave here thinking that it's a wild, wild west on the VCCs, right? Certainly, from a derivatives perspective, we've said once you put a derivative over an underlying asset or underlying, even if the legal nature is uncertain itself, you bring yourself into the capital market space where you actually are subject to certain rules. So, and if you are really a bad person trying to do fraud, commit fraud and so on, there are laws against you. So again, the shout out for the VCM market, it's not a wild, wild west place there, which you can do what you want, I guess. So that's something which message you want to leave for everyone. There's another point here, another question here, which again, maybe I'll ask Robin. Again, it's not related to the topic at hand, but I think it is important. How do you see the convergence on the compliance market and VCM market impacting this issue? I guess the two parts, that one is convergence of the compliance market and the VCC market, and you started off saying that the VCC market tries to fill up something or the gaps in the compliance market, but the convergence itself, maybe you want to speak a few minutes on the convergence itself and how you see this issue panning out.
Yeah, in many ways, I think it's a good question. I think in many ways the VCM is becoming an increasingly inapt term, and it is, it's more of an independent crediting programs that can feed into various markets, some of which may be compliant, some of which may be voluntary, or philanthropic or otherwise. I think to sort of bring this back to the issue, I think it is of interest to me at least whether or not there's any implications on the permanence prong that was discussed previously. I mean, we are aware that in a world where the VCM grew up in the margins and countries didn't really seem to sort of care too much, that maybe that raises one set of issues versus another where, you know, is there a risk, especially in a world where there are Paris commitments and Paris-derived commitments, what does this look like in terms of the possible privatization of a public good or a natural resource? And, you know, how are governments going to get in on that? What are they going to say about it? What does this mean for revocation and so forth? And so I'm curious to know whether or not that will affect any definitions that we may have established. I think what it does call into the need that if these markets are springing up and we're starting to feed into those, do we need more regulatory certainty about what we are in the first place? And does that require some sort of approval process or whatever? We're preparing for that outcome internally, but I think that the book isn't quite written on how that's going to play out.
Okay, good. Thank you. So there's another question here, and this is really, I think, a question principally, I think, maybe for free legal advice, so I'll send it to Richard. From a financing collateral perspective, do you see any particular advantage that security over VCCs can, by way of pledge or charge over an assignment? I suspect maybe that's perhaps also for maybe some other practitioner here also trying just to lean on your expertise.
So this is quite a technical question, isn't it? So strictly speaking, certainly as a matter of English law, as intangible property, a pledge just wouldn't be available. I know that the term pledge is used in quite a large sense. I think the key question from the market is, and charges or other forms of security would be available, is the technical answer. I think the interesting question though is how much is this market really going to mirror the financial markets? And you know, how much is legislation like the financial collateral arrangements regime in the UK and the EU and other regimes in international jurisdictions that alleviate formalities that apply to the taking of security? How much is this market going to look like the financial market? So how much are those alleviations going to apply, because they currently don't, at least certainly from an English law perspective, and you do have to register, et cetera, et cetera. So I think that's really the core question for me. And the more that this market looks, and the development of the secondary market in particular, the more that the secondary market develops, I think the more that we are going to see pressure on lawmakers to include specific alleviations that make the grant of security, buying, selling, etc., that much easier. And in particular, I think that, to all of the comments earlier, that will also hopefully spur activity in the financing markets.
Great. I think, as you mentioned earlier, there's on harmonization and its path forward, and in the paper you talk about regulators needing to take a stand and so on. So one question here we have is, what is the path forward? So it's a very short question, but I think it's extremely loaded. So
yes, it's extremely loaded. The path forward. I think that there is quite a bit of movement in the different organizations, the conversations, that there's a possibility of harmonization, but it will take time. So how long it will take, I don't know. But in the meantime, are we going to be swimming in uncertainty? I hope not. So I feel that's why there is a need to kind of help the market in the meantime to have a little bit of certainty, and yet not kind of go wacky, right? Come up with different categorizations. You just use the same principles and think hard about it. If there is a true lack of legal certainty, I feel that if we have environmental integrity, maybe we will go some ways in still developing the market, because that is kind of key. Environmental integrity, financial integrity, and hopefully this question is kind of like, at the background. But when there's lacking in both, I think there will be disputes that will come up, and this will be front and center.
Great. So I think we're probably at the end of our session. There are a whole bunch of questions here. I think they picked up. So I think the panelists will be free to take any questions after this session. It's been very interesting, riveting, and I guess nothing has been solved today. Not that I know of, but again, it's actually the spur of the conversation for you guys to think about it, and also to take back, right, to be a part of the solution, whether it's through different forums, standards, legal associations, writing in, and so on. So we hope to get more participation, at least from everyone on this space, which is pretty important, pretty critical. I will actually ask, sorry, there was one question here which we can't answer, which I thought was pertinent. How are carbon credits reflected on the financial statements, if at all? So maybe if there are any accountants here, you feel free to put up your hand and stand by the corner, and someone can ask you that question.
Our finance team will tell you.
Yes, right. And with that, so it just leaves me to say thanks very much for joining me on this panel, Richard, Robin, and Ting. Thank you.
Thank you.